Good morning and welcome to our panel this morning on intellectual property and the right to repair movement. My name is Adam Mossoff. I'm the moderator of today's discussion. I'm Senior Fellow and Chair of the Hudson Institute's Forum for Intellectual Property, and I am also Professor of Law at the Antonin Scalia Law School at George Mason University. We have a fantastic panel of experts to talk about the important legal, constitutional, and policy relationship between this growing right to repair movement and the intellectual property rights that are secured to innovators and creators in the United States. Now, the right to repair movement has grown, as I mentioned, significantly in recent years, as proponents have argued that consumers should have a right to repair all of their electronic devices and that this is necessarily in the public interest. Now, as a result of these arguments, many bills have now been introduced in state legislatures throughout the country and in Congress, mandating actually that consumers be given access to all materials to repair a myriad of products that they may own, from tractors to iPhones. And these bills thus mandate access to both computer code and other copyrighted works that may be incorporated into these products. As such, these legislative proposals generally conflict with federally protected intellectual property rights. And the state bills in particular overlook long-standing federal policy that IP rights serve the public interest, as well as the constitutional supremacy of federal laws over state laws. Right to repair advocates really don't acknowledge how IP rights have also been central to the success of all sectors of the U.S. innovation economy, from the creative industries to the gaming industry, and of course to the high-tech industry. Now, to discuss these issues, we have two fantastic copyright experts. I will only be giving their immediate titles and institutional affiliations because you could easily find their very lengthy list of successes and publications and other affiliations by Googling them on the internet, which I recommend that our listeners do. But you would rather hear them talk about these issues as opposed to me going on about their achievements. We first have Devlin Hartline, who is legal fellow at the Hudson Institute's Forum for Intellectual Property, and he researches a broad spectrum of doctrinal and political issues in intellectual property law and policy. And we also have Kevin Madigan, who is Vice President of Legal Policy and Copyright Counsel at the Copyright Alliance. All right, now to kick us off, I'm going to first pose a question to Devlin, and that is, before we dig into the details of how various right to repair laws have been proposed and what are the content of those laws and the issues that they raise in law and policy and even constitutional law, perhaps just briefly describe what is the right to repair and what is happening in the state legislatures in particular.
Great. Well, thanks for the question, Adam, and thanks for moderating this panel. I'm excited to be here to talk about these important issues. So the right to repair movement is based on the notion that if you own something, you should be able to do whatever you want with it. And so you can think of the tinkerer in a garage. When my dad was younger, he could take apart and rebuild the carburetor in his car. But cars started to get more complicated and carburetors were replaced with computer controlled fuel injection systems, all protected by IP. So he had no idea what to do with these newfangled things. He didn't have the tools, he didn't have the know-how. And so the right to repair movement acknowledges that our devices are really complicated, but they want to create more opportunities for consumers to either repair them themselves or to have them repaired at independent repair shops. And so, as you mentioned, the way they do this is they mandate that manufacturers have to turn over the parts, the know-how, things that people need in order to repair their devices. But what they often leave out of these conversations is the fact that many of these things are protected by intellectual property laws, whether patents, copyrights, or trade secrets. And so the IP system allows that these manufacturers, the owners of the IP, to decide for themselves whether and how these things get distributed to the public. So there's this significant tension between the right to repair movement and the rights of IP owners. You mentioned the state legislatures, and so we're seeing some interesting things happen there. proponents are asking for these right to repair laws, but they don't even acknowledge the fact that they have implications for IP rights that are secured under federal law. And we'll get into that a little bit later. But if we take a step back, we're actually seeing like this multi-prong attack on IP rights in the state legislatures. It's often sold as trying to protect consumers in some way. And so we've seen states try and force publishers to license ebooks to public libraries in the states. These laws are being struck down by the federal courts because they conflict with federal IP law. But the right to repair movement in the states, they're using the exact same playbook. And so, in fact, Adam and I have recently published a Hudson Institute policy memo about these state right to repair bills, and we explain, why they're unconstitutional and why they're a bad idea. And we'll get into that a little bit later. But I'll just note too that a lot of the advocates for the right to repair just so happen to be the very same people who have been trying to weaken IP rights for the last few decades. And so it's no coincidence. This is just another way that they're attacking the rights of IP owners.
All right. Another great kind of foundational question first to ask too, to kind of serve as the basis for our discussion today, or this morning at least, is everyone, of course, loves their electronic devices. But many people are unaware of the actual key role that intellectual property law has served in the success of technology markets, and especially in the explosive growth of our digital devices, our smartphones and our tablets, on which we enjoy the incredible creative music, movies, books, and games that we all benefit from. Kevin, could you describe some of the role of intellectual property law in making our modern digital devices even possible?
Sure. And first off, just thank you, Adam, for inviting me to speak on this panel, and also to the Hudson Institute for hosting it. So as Devlin sort of got into a little bit, these days, most everything we own, from our car to our phone to, our toothbrush even, are smart devices that either run on or incorporate, software, which incorporates copyrighted computer code. Not only that, but copyright protected works are distributed more and more these days in digital formats, whether it's the movies, TV shows, or video games and music that we stream, or the books we download to read on a tablet, or the software we run on our computers. It's all digital. Not many of us, are still out there buying compact discs or DVDs. So now intellectual property and copyright specifically play a huge role in the creation of these expressive works, whether they're physical materials or the embedded computer code that make up a piece of software, which I should mention, software is protected as a literary work under the Copyright Act. And copyright protection acts as an incentive for the creation of works that creators and copyright owners can then commercialize and control in the marketplace. But I should also mention there's a part of copyright law that specifically protects the copyrighted material that's distributed in digital form, and that guarantees copyright owners that their works won't be infringed once a digital product or device is sold or licensed or otherwise enters the marketplace. And we'll talk a little bit more about that later, I think. But in the digital age, so many of our devices and equipment and vehicles incorporate copyrighted code to function, whether it's a refrigerator or a phone or a tractor or a car. All of these things incorporate intellectual property, which allows developers and manufacturers to protect their products and commercialize them without fear of infringement. And the returns they get from the sales of these products, in turn fund the next generation of devices and creative projects. Without intellectual property protection, those returns would be threatened, and there would be less of an incentive to invest time and resources, into the next great device or work. So I would say intellectual property plays a huge role in the development of digital devices and copyrighted works that are distributed in digital format, and the ability to protect the expressive content that we consume digitally is really critical to the continued success of the devices and the works that are embedded in them or that we access through them. As Devlin mentioned, there are some bills introduced both at the state and federal level that don't really seem to take into account the copyright implications of right to repair, but I think we'll talk a little bit about those soon.
Yeah. As you described it, you really kind of, I think, nicely kind of made clear the reality of Mark Andreessen's, famous statement about a decade ago that, software has eaten the world. It's in everything, and it's a creative expression. Coders really do engage in, writing and an important type of language that it makes possible all these incredible devices and products and services that many people just seem to take for granted, and they don't realize what's made them possible. So Devlin, to come back to you, what about the issue of what intellectual property kind of represents? I think Kevin nicely described how it functions, but the right to repair movement seems to presume that there's something seemingly it gets wrong. I don't know else how to say it, with intellectual property owners deciding how to sell their products and services that are protected as intellectual property, and yet it does seem to be a fundamental principle in our country that that all people should be secured in the fruits of their productive labors, right? And so, doesn't intellectual property represent the same principle that we're securing property rights to the innovators and creators and their new inventions and creative works?
No, absolutely. And as Kevin explained it, it's the IP in these things that makes them so wonderful. And yet people complain, oh, the IP is getting in the way of me enjoying them. Like it doesn't make any sense. But the right to repair movement, it wants to force IP owners to hand over these tools, these parts, this documentation, this know-how to individual owners and repair shops so they can repair their own stuff, right? But many of these things are in fact protected by IP laws. That's the tension. And so the parts might be patented. The software, the operating system, all that stuff is copyrighted, as Kevin discussed, as a literary work. And then you've also got these TPMs, technological protection measures, that prevent unauthorized copying or unauthorized access to these copyrighted works. And those are protected under the Copyright Act. And you've also got trade secrets, right? So tons of IP goes into these things. And if we're going to talk about repairing them, then we've got to talk about what are we going to do with the IP. So why do we even have IP? We give IP owners exclusive rights, which are property rights, so they can decide for themselves whether and how they distribute these things in the marketplace. And the premise of this goes back to the Constitution and predates the Constitution, of course. But in the Constitution, it says that the best way to promote the public good is by empowering creators and innovators to pursue their own private interests. And so the IP system has obviously worked really well for over 2 centuries. And we give these rights to IP owners for 2 reasons. We want to incentivize the creation of these valuable things in the first place. And we also want to reward creators and innovators so they can recoup their investments and make a profit, right? So it's a great market-based system, and it works. But the right to repair movement seems to think that all of this nonsense about incentives and rewards, we don't need to worry about that. In fact, it's a problem that we can just route around it, right? Like and everything will be hunky-dory. But that's not the way it works. We have to think about, if we make these changes, how is it going to upset the legitimate expectations in the marketplace that these creators have? Are they still going to create these things? Are they going to distribute them if we weaken their rights? And the repair advocates that seem to think that that IP owners exercising their IP rights in the way that Congress intended, in the way the Constitution intended, is somehow abusive and harmful to consumers, which is just I'd say laughable, but it's kind of sad. But this is what they're arguing, and in fact, it's just a shorthand. They just want to weaken IP rights, and as I mentioned earlier, this is just another vector of attack in a long line of attacks on the IP system. But the Supreme Court has made clear that IP owners don't have to license or sell their creations or their innovations to other people. There's nothing wrong with that. It's literally the basis of the IP system. You've got repair advocates throwing out rhetoric about monopoly abuse and antitrust concerns, and it's a bunch of nonsense. IP owners are doing exactly what the IP system wants them to do, and so there's also this notion that that IP owners are purposefully making it more difficult for people to repair their devices. And I'll talk more about that later, but that's an absurd notion, right? It's a highly competitive marketplace. They're not in the business of making consumers angry, right? They want to use their IP to make consumers happy. And so those arguments just make no sense. What IP owners care about is their rights being eroded, that their investments in these things aren't going to come to fruition. And it seems like repair advocates that simply don't care about these things, which is really concerning.
I would actually just like to add one thing there, that I think a lot of the advocates for some of these broad right to repair exceptions also ignore the fact that there are plenty of exceptions built into the law that allow users and consumers of copyrighted works to use them for certain purposes, including repair. There's things like fair use, there's the first sale doctrine, and then Section 117 of the Copyright Act that allows for repair. But when you're dealing with a work that is embodied in digital format, the exceptions often don't apply as broadly because of the ease with which digital works can be copied and shared, and the fact that unlike a physical version of work, they won't be worn down or lose fidelity like a book or like a vinyl LP would. So whereas in the days before the digital revolution, when copyright owners were distributing mostly physical versions of work that would take a lot more effort to copy and distribute, in the digital age, it's really essential that copyright owners are able to protect their works that they distribute through the technological protective measures that Devlin mentioned, and then they are able to through the Digital Millennium Copyright Act, which I think we're going to talk about in just a minute.
Yeah, in fact, your follow on to Devlin kind of raises the thought for me that is this or what you're talking about is the law that Congress enacted in 1998, the Digital Millennium Copyright Act. Because Devlin mentioned, the copyright and the intellectual property system has worked great for 200 years, but it did seem that the internet revolution and the ease of piracy facilitated by digital copies, really kind of changed things dramatically, and that Congress responded accordingly. So can you talk a little bit more about those types of protections and how are they implicated by the right to repair?
Yeah, absolutely. So as you mentioned, in 1998, Congress enacted the Digital Millennium Copyright Act, or the DMCA. And one of the main parts of the DMCA is Section 1201, which safeguards these technological protection measures, or TPMs, that are used in connection with the dissemination of copyrighted works against compromise. So basically what TPMs do is prevent unauthorized access to any number of copyrighted works, movies, music, books, software, video games, other copyrighted materials. And importantly, Section 1201 prohibits not just the circumvention of the TPMs, but also the trafficking in technologies that would allow for circumvention. But as I mentioned, I think it's important to understand that 1201 includes many statutory exemptions for things like security testing and research. And it also provides for a rulemaking process that's conducted every 3 years, through which the Copyright Office considers and adopts exemptions to the Section 1201 protections. So it's like this, balanced and flexible system that has contributed to consumers today having really a wealth of ways to safely access and enjoy all sorts of copyrighted works, and creators having new platforms to reach their audiences. But rather than petition the Copyright Office for repair exemptions through this triennial rulemaking process, some of the bills we've seen really introduce these broad overriding provisions that basically say that 1201 is just not. They can override it completely and allow for broad circumventions that are related to repair. But again, the proponents of these bills sort of disregard the fact that it was Congress who created this flexible rulemaking process where all the stakeholders come together and participate. They can petition for exemptions, others can come forward and impose those. And it's really a good process for everyone to be involved and everyone's voice to be heard.
I'll just add too that with Section 1201, it's amazing to me that repair advocates they never point out to anything good that ever happened under the DMCA, right? It's all about bad things. But 1201 protects password protection. You're trying to log into Netflix, encryption. So when you get your digital satellite radio, it's encrypted, right? So and this protects that, and so it protects these works so that they can maintain value for the creators. And we have all of these wonderful things because 1201 protects these things with these TPMs, right? And what's crazy is like the exceptions that were mentioned already, fair use, Section 117, and the exemptions that come in the triennial rulemakings. They're all very narrow. They're narrowly applied, especially the exemptions. They're only for 3 years, and the burden's on the proponent to show that there is significant non-infringing uses that are being blocked, right? And you have to show that it's not going to lead to widespread piracy. And you can get these exemptions, but they're all very narrow. And what do these bills do? They're just like this blunderbuss approach, just like, forget about TPMs. Don't worry about copyright. It's all going to be good because people are going to take apart their Nintendo Switches and like micro solder. No, they're not. Like, it's crazy.
Yeah, I don't know if it's apocryphal, but I've heard that that the Digital and Copyright Act played an important role in Steve Jobs being able to convince the labels to start iTunes because they were very concerned about music being made available and being able to seamlessly and easily and costlessly being copied on the internet. And he was able to say, we will protect it with technological protection measures, and we will prevent the copying of this. And the DMCA is what makes that possible for him to have made that promise to the labels that we will be able to secure you in your creative works and facilitating this new incredible digital market that we're about to create. And so it's interesting that they always say, oh, nothing good has come of the DMCA, but and then iTunes leads to the iPhone. And
yeah. It's like, do you like Netflix? You can thank TPMs. Yeah.
Now, Dylan, it's interesting. You keep mentioning that they criticize the DMCA or they criticize copyright owners for suppressing content or for preventing consumers of their products and services of benefiting from them. But if I recall, the bills actually don't mention copyright law at all, either in the states or in Congress. Are the proponents simply not recognizing that the bills implicate copyright law, or is there something else going on here? Why are they, on the one hand, in the policy debates talking about how copyright is such a problem, but in the actual legal framing of it, there's zero acknowledgement of the actual implications with copyright law?
Yeah, that's a great question. And I can talk about the state bills. I do think some of the federal bills do recognize that there are copyright issues, but the state bills don't, which is insane, right? So you've got many states, I think a majority even, are now considering these right to repair bills, and they all follow this model legislation that was put forth by a group called the Repair Association. Repair.org is the website. You can see it there. And so, as you and I noted in our Hudson Institute policy memo on these state bills, is that they completely ignore the fact that there are copyright ramifications, right? And this doesn't seem to be an accident, and I'm convinced that it's not. And so how do we know? Well, the Repair Association's own website acknowledges or claims that copyright law often stands in the way of repair. And many of the groups advocating for a right to repair, like the EFF, it's like copyright law bad, copyright law bad. Like, this is their mantra, that copyright law is preventing us from repairing our devices. And then they go to the states and they say, hey, states, we want you to pass these bills so we can repair our devices. And then mum's the word on copyright law, right? And so they have to be quiet because they know the problem, right? And so this is what we get into in our policy memo. But they know that these bills have serious copyright problems, and they know that states are simply powerless to conflict with federal copyright laws. And so the state bills that are based on this model legislation have two copyright problems. So one, they would force the device manufacturers to hand over copyrighted computer programs. So like these diagnostic programs you use to figure out what's wrong. These are computer programs. They're copyrighted works. They're protected by the Federal Copyright Act. And perhaps even more perniciously, they want them to turn over the keys to the TPMs, the technological protection measures that protect these copyrighted works from unauthorized access and copying. So they want them to hand over these copyrighted works and the keys to the digital kingdom, right? And so under our system of government, federalism, you've got state law and you've got federal law. Well, the supremacy clause in the Constitution says that federal law wins when there's a conflict. And so there's a huge conflict here, right? Under federal law, copyright owners can keep these things to themselves. I don't have to, if I own this stuff, I don't have to share my copyrighted programs with somebody else. I certainly don't have to turn over the keys to the digital kingdom, right? But under state laws, they would actually be liable for exercising their federal rights. And so these laws are what lawyers call preempted, right? So they're unconstitutional and they're unenforceable. Why? Because they directly conflict with federal law. And so if repair proponents want these things that are going to affect federal copyright law, they have to go to Congress. And they are, in fact, going there. There are bills in Congress, but they're also trying to drum up momentum in the states with these laws that I have to think, they know they're unconstitutional. But I just think that they're trying to get some momentum going in the states, and then hopefully they can push that into Congress and get some kind of federal action there. But they can't have it both ways. They can't say copyright is the problem and here's the solution. Oh, and the solution doesn't have anything to do with copyright. Like it doesn't work that way. And in our policy memo, we explain why they're just wrong on the law, but they're also just wrong on the policy, right? They're upsetting the balance between consumers and copyright owners. And the things that they want are just so extreme that Congress wouldn't go for them, right? Like there's no way. And so it's a losing battle. And we've seen that, we just talked about the things that are out there now, these carve outs are very narrow and what they want is just incredibly broad and just would run roughshod right over IP, right? So I don't think it's going to happen the way they want.
Yeah, and it's really it'll end up also just being a really unfortunate, tremendous waste of valuable resources, scarce resources, especially at the state level. Not only in the states enacting these laws, but then going through the inevitable litigation where courts will be finding these laws to be preempted. And all of this is just as I think as you described, right, is just really a policy effort to trying to create movement for at the federal level, but at the state level. If I recall, one of the reasons why they're able to ignore or not talk about copyright laws because they're framing this through state consumer protection laws, which the states do have the authority to adopt. And so they're arguing that this protects consumers in certain ways, as Devlin has described. Kevin, are there potentially reasons aside from kind of the constitutional concerns and some of the concerns about the conflicts with copyright law and the balance in copyright law, federal copyright law generally? Are there some concerns that these bills might actually harm consumers as well?
Yeah, I think so. And why don't I take a step back and just talk briefly about some of these bills that have been introduced at the federal level. So there's been a handful introduced in both the House and Senate over the past year and a half or so. And it's sort of hard to say whether the various authors of these bills recognize the copyright implications. There are some of the bills that really don't mention copyright or Section 1201 at all. They sort of simply call for equipment manufacturers to make diagnostic and maintenance repair equipment available to independent repair providers. And they seem sort of narrowly targeting like farm equipment and tractors. And by making no mention of copyright or 1201, those bills don't really affect copyright owners' ability to use 1201 to protect their works through technical protection measures. So they aren't sort of as worrisome. I'm thinking of one particular bill that was very narrowly tailored to address only farm equipment like tractors. And it actually included a savings clause that says nothing in the bill shall be construed to permit the evasion of copyright laws. So those aren't as really troublesome, but there are bills that would amend or override copyright laws and that expressly permit the circumvention of technological measures for a wide range of purposes that are not well defined at all. Some of them would also allow a person to, quote, manufacture, import, offer to the public, provide, or otherwise traffic in any technology, product, service, device, component, or part thereof that is primarily designed or produced for the purposes of use in circumventing a technological measure. Sorry, I know that was a mouthful, but it just gives you a sense of really the broad scope that some of these bills have. Yeah, that's really problematic language that would basically allow for people to develop and distribute devices or programs that are built to crack technological protection measures, and would also incentivize entire industries that would be based on infringement. So while it seems like some of the bills, come from a place of good intentions, some are way too broadly written and would threaten entire creative industries by opening the floodgates to infringement, which would in turn make creators and copyright owners less willing to release their works in certain formats at all, or through certain devices, and software developers may be less willing to have their codes embedded in certain devices. And I think, there's a real danger in laws that would allow for widespread circumvention of TPMs. For some of these devices and equipment, we're talking about heavy machinery, tractors and cars, and you don't necessarily want to make it easy for people without repair expertise to crack into the software and tinker with the inner workings of these machines. There's also things like smart medical devices that we don't want sort of the average person tinkering with. There are life and death consequences to something like that. But even for things that may not have such a serious life and death consequences, there are issues with TPMs that protect video games and gaming consoles. And while they primarily protect against people accessing and playing pirated video games, they also protect consumers against viruses and malware and people trying to steal identities or credit card information. So I think there is a lot of harms out there that aren't necessarily being considered by some of these advocates.
Yeah, I mean, to kind of circle back to Devlin's earlier example of his, I think it was your grandfather, his inability to repair his car, or father, right? I have the same issue with my motorcycles. I have an older motorcycle before they were implemented computers, and I can do a lot of repair work on that. I have a newer motorcycle that is completely computerized, has computer control of the carburetor, computer control of anti-lock brakes, and all sorts of stuff. I don't want to be messing with that. That's the last thing I want to be. I want to be trying to, quote, repair. Discover that my skills only go so far when I'm going 80 miles an hour down the freeway. But to circle back also to kind of my earlier reference to Steve Jobs and iTunes, Devlin. So you and I had recently chatted about this. So that Apple had launched that new self-service program where they said, fine, our customers want to repair their iPhones, we'll send you the kits with the tools and everything to do to do this. And yet there were tremendous complaints about it. And so what do you think is really going on here? What did that exemplify as an example where a company finally said, okay, fine, here's the capability to repair the products that you had to replace the battery or something, and yet people still weren't happy with it.
Yeah, this cracks me up. So the genesis of this was an article in Verge. I think it was last May. There's this guy right to repair advocate, and he wanted to replace the battery in his iPhone. Well, I'm an iPhone guy. I know it sucks. You got to go down to the Genius store and they'll do it. On the earlier model phones, I think my first iPhone and iPhone 3, I did it myself and, pried it apart and stuff. But now it's like, it's really hard to do that. And so he wanted to do it himself. And so he went to Apple. They had just launched this new self-service repair program. And so they sent him the genuine parts. They sent him the tools and all of the know-how, like 80-page documentation on how he could do it himself. Well, the tools were the professional industrial grade tools, the same exact tools that the guy at the Genius Bar uses, right? And it ended up being like 2 Pelican cases weighing like 79 pounds. and apparently this guy like rode the train home, like lugging these cases. And so, for example, it included this industrial like oven that you put your phone in, and so it heats it up because there's glue in there, so it loosens the glue, right? And so they're like, here's all the stuff that you need. And so despite having all the tools and step-by-step instructions, he's like, wow, this was really hard to do. And it's like, well, yeah, duh. Like the guy at the Genius Bar does it all day long. If your first time doing it, it's not going to be easy, right? And so what are his complaints? He complained that that repairs used to be easier. And this is what my dad used to always say, like I remember my first car that had fuel injection. He's like, oh, I don't know how to work on that car, It's like, well, yeah, I don't either, right? Because they're too complicated. And he had to put down a deposit for the tools, which was like $1,200. And so he complained about that, and it's like, well, if you get the tools for a week and you give them back, you get your $1,200 back, right? So just not happy. And so, and this was the best part of the article. So Apple actually paid for the shipping, these 79 pounds of tools, paid shipping both ways, and provided a dedicated support team. You could go online, and if you were having trouble, you could get answers right away, right? And so he said that these two things were proof that Apple doesn't want people to repair their own devices, because his reasoning was it's got to cost them too much, right? Like the shipping on these 80 pounds of things must cost more than they were making, and then at the same time, he complained that when they sold him the genuine battery, it actually cost the same as if he'd gone into the Genius store and had them replace the battery, right? And so anyway, he's trying to have it both ways, right? He's complaining about all the fees, but then he says they must not like repair because they're not charging enough, right? So they're charging too much, they're not charging enough. I get it. These small devices are like, they're super complicated. And so, years ago, if you had a fancy watch, you didn't fix it yourself, you went to a watchmaker. Well, think about all the devices now. And we're an Apple family. We've got iPads, Apple Watch, we've got iPhones. And so I could have picked a device that had removable batteries. And for me, that actually would be a plus. Like I would like to be able to change my battery myself. That would be a good thing. But you weigh the pros and cons when you buy these things. And so we really like Apple products and overall like the Apple ecosystem. And so in my family, we're happy to do this. And we buy these things knowing that if something goes wrong, I can easily get it fixed. I happen to live close to a Genius Bar, not too far away at the mall. But I've also had repairs, like my son broke his iPad and I had to mail it in. And it's the simplest thing, right? They pay if it's under warranty, they pay the postage, you mail it to them, a week later you get it back, it's good, it's new, right? So it's these, I don't, what are they complaining about? They seem to want like the Joe Bob on the corner to be able to take apart my iPhone and get all the genuine parts and know-how and all that. But, that's why we have authorized repair centers, right? So they get the training they need, they get the expertise, and you're getting it done right. And so it seems like they're complaining about a problem that isn't really a problem, and it's just one that doesn't make a lot of sense to me. So what do they really want? I think they want like the world's most cutting edge technology that you could ever have, that's getting smaller and smaller and smaller. But at the same time, they want it somehow magically to be easier for people to work on these things themselves. And that's just not the reality of the world, right? This isn't my dad's 65 Chevelle, right? These things are really complicated.
So Many of these issues, I think, have been around for a really long time, and other agencies have been studying them and have been investigating them. And Kevin, the Federal Trade Commission, took a look at this issue and concluded in its 2021 report called "Nixing the Fix" that, quote, "the assertion of IP rights does not appear to be a significant impediment to independent repair," unquote. Do you think that was the right conclusion reached by the FTC in that case, or in that issue?
Yeah, I do. And that report points out, and I mentioned earlier that there are many statutory exceptions to copyright law that allow for repair and uses related to things like research and security testing. For instance, Section 117 of the Copyright Act provides that the owner or lessee of a machine may make a copy of a computer program for purposes of maintenance and repair. And then, of course, there's the triennial rulemaking process that I mentioned earlier, where the Librarian of Congress and Copyright Office has permitted the circumvention of TPMs to diagnose and maintain or repair vehicles and smartphones and home appliances and other home systems. So, not only are there permanent exceptions in the Copyright Act, but there's a flexible procedure where people can petition the Copyright Office for exceptions if they make a good case for one. And I think the FTC report also basically says that there may be some impediments for certain users to make repairs however they want to. It's not necessarily an IP rights issue that's driving the impediments. There's other factors at play. There's competition law, there's cybersecurity issues that also play a role. So I think they were right to come to the conclusion that this is not an IP problem.
Yeah, it does seem interesting that that every time someone actually looks at the actual institutional, legal, and regulatory environment that already exists, they discover that there's all of these mechanisms that already pre-exist to address the concerns raised by the right to repair movement advocates. So we're coming up on the end of our time, so I think we just have time for just one more question. So I'll throw it out to Devlin to kind of to bookmark our or bookend our event today. So video game consoles seem to have received special solicitude when it comes to the triennial rulemaking proceedings that Kevin has described under the DMCA. What makes these consoles so special? And should this reasoning be extended to other digital devices?
Well, so this is a great question. I've got two teenage boys, so I think a lot about video game consoles, and they break when you drop them, as I found out. And so with video game consoles, you've got the embedded software that's copyrighted. So this is the firmware, the operating system, what have you. But you've also got this other thing to think about. So you've got all of the copyrighted content that makes the console so great. So this is the video games that you play, but you can also watch movies, TV shows, you can listen to music. So you've got all this copyrighted content that you enjoy on your device that has embedded copyrighted content, all protected by TPMs, right? So there's a lot of copyright going on with these things. And so the concerns here are twofold. We're not just worried about the manufacturers of the consoles, but we're worried about the game developers who make the games, the film studios who make the movies we watch, the musicians who make the music we listen to. So there's this entire ecosystem at play. And so again, repair advocates kind of just gloss over all this stuff and say, anything that limits our ability to repair our Xbox is totally not in the public interest, right? And so this is nonsense. So there's this notion that they're trying to make repairs unnecessarily difficult, which just makes no sense, right? Like, why would console manufacturers want to make something that needs frequent repairs in the first place, right? That's bad for business, and they want happy customers. And when something does need to be repaired, they have every incentive to make it quick and easy. There's a highly competitive market out there, and honestly, they're not making bank on these repairs, right? I would be surprised if they even break even on these repairs. They're not doing the repairs for money. That's not where they make their money. And so there's all kinds of things that go into the design of these things, right? It's complicated, and manufacturers are trying to balance things like cost aesthetics, efficiency, durability. The ease of repair is just one factor that goes in when they're designing these things. And so the council makers have this vast network of legitimate repair technicians. They give them proper training, they give them the parts, they give them the tools. And so this ensures that when you go to them, that you're getting quality repairs that are done right. And these people are going to protect your privacy and your security, right? So we have a lot of personal information on these devices. We don't want it to get out. But at the same time they're protecting us, they're also protecting this entire creative ecosystem. And so they make sure that there's not piracy that's going to hurt innovation in this space. And so console makers, they're concerned about people hacking these systems, installing malware, stealing your private info, or even cheating in online gaming, right? Which happens all the time. And this isn't some theoretical problem. There are sophisticated international criminal rings that are dedicated to cracking these consoles, and these groups rake in millions of dollars, right? And this has been going on for decades. And so sometimes when you replace a part on a console, it runs like an authentication check to make sure it's a legitimate part, right? And so they want to make sure that there's not going to be some kind of illicit hacking that could be harmful to consumers and to manufacturers alike. And so we were talking about the triennial rulemakings. So you've got the Librarian of Congress, the Register of Copyrights, every 3 years. They look at what exemptions should we grant. And so for cycle after cycle, there were no exemptions for video game consoles because they understood all the problems of piracy and things, right? And so you would get exemptions for vehicles, smartphones, microwaves, whatever, but not for consoles. In the most recent one in 2021, we finally have our first exemption, which is for optical drives. So like DVD drives. So now you can pop out your broken DVD drive and plug in a new one, and you can circumvent the TPM that authenticates it. But you have to put it back. You have to re-engage the TPM, and you can't use it to gain access to copyrighted software that you don't have access to, right? So it's a very limited exemption, and this is the point I'm trying to drive home with these exemptions and exceptions that exist. They're all very narrow. So if you want an exemption from the Librarian of Congress at these rulemakings, the burden's on you. You have to show it's not going to lead to widespread piracy. You have to show that these are non-infringing uses. You know, so repairing something is non-infringing, but they don't want to open the piracy floodgates, and so they don't want to harm consumers. They don't want to harm manufacturers, and so we're seeing the exact opposite approach with the right to repair movement. Right? It's this blunderbuss. Let's just blow the whole system up. Who cares about all that other stuff? It's inconvenient. Let's route around it. But honestly, I can't imagine. I don't know Nintendo, but I imagine they have like the keys to these TPMs, and they're like locked in a vault that's locked in a vault, and there's like 2 people that know the combination, and they only know half. Yeah, they have to like come together and turn the keys at the same time, or I don't know, right? And so, but the right to repair movement's like, oh, those things, everybody should have those keys, right? And it's just insane. And so, like the video games are a huge market. It's a huge successful market, and it's because of IP protection, not in spite of it. And like I said, they break when you drop them in, and it's so easy. So and I've done this more times than I want to talk about, but you put it in the mail, you get it back a week later, and it's fixed, and it's like good as new, right? And so what is the problem?
Well, yeah, I think you made a really good point about the flipping of the presumption, right? That, it's been the long-standing policy rooted in the Constitution in this country, as both of you, I think, have very admirably and succinctly described, that intellectual property serves the public interest. It makes possible our flourishing innovation economy, a flourishing creative industries, and all of these incredible devices and creative content that we enjoy today, especially thanks to the mobile revolution. And that whole basic presumption is flipped entirely on its head with this kind of, as Devlin describes, this blunderbuster approach, where the presumption is all, no, intellectual property shouldn't exist, and the burden should be on the IP owners to show whether they should actually have protection or not against these claims to repair and other claims to weaken their rights. Well, this was a really fantastic, robust, and even fun discussion with you guys. Thank you very much, Kevin and Devlin, for a fantastic panel event again. Really delighted that we were able to host this today. And for those who are watching this, please take a look at the policy memo that Devlin and I co-authored and published at the Hudson Institute just a couple months ago. Thank you very much.